Okay, we are live. Hi, everyone, and welcome to the Real Estate Educational Series with Anna Stepchenko. I'm very delighted to be here again. And today, once again, I'm having a guest who no longer needs any introduction. However, for those who are watching us for the first time, I'm very delighted to introduce the Sunny Isles Commissioner and a real estate attorney with over 15 years of experience, Dana Goldman. Hi, Dana.
Hello. Happy to
Dana,
be here. Thank you.
Thank you, Dana, and I'm also very, very delighted to have you back. Dana, today we will be discussing a very essential topic for the Floridians, for those people who relocate to Florida from all over the world. And this topic is related to the condo association move-in fees that are charged by a condo association in connection with the sale, lease, or transfer of the property. And for those people who understand very little about what I'm saying, I would like to point out that any condominium in Florida requires an applicant, a person who is buying or renting, to go through the condo application process, through the approval process, and such process costs a certain amount of dollars. And depending on which condo association you decided to work with, such fee may vary from $100 all the way to $300, $400, $500. So Dana, the question to you is, according to Florida Condominium Act, what is the legal maximum cap that a condo association can charge to a potential buyer or to a potential renter?
Okay, that's a great question. And actually, this is a pretty hot topic because it has been the cause of some very intense litigation in recent years. There is in the Florida statutes, and specifically the Condominium Act, a prohibition against charging any more than $100 in what's called a transfer fee per person or married couple. So that includes application fees, credit checks, background screenings, move-in fees, registrations, and other charges related to the sale or lease of the unit. So embedded in the Florida Condominium Act is the $100 cap. Now, what's interesting about that is, if you think about it, so associations, they probably have a lot of costs involved when a person moves in and moves out, right? A transfer,
Sure.
a sale or lease. They've got to do background screening, maybe tenant checks. There may be a higher cost than the $100, but the associations have to be very careful because there is a risk that they could end up in a lawsuit if they charge more than that $100 amount. And in fact, there's a very celebrated case in one of the Brickell condominiums where they were subject to a class action suit. So if you add up $100 times 500 plus unit owners over a 5-year period of time, it's substantial liability for the association to really collect more than that $100 fee per person or married couple.
And you know, this is very important that you brought that up, because I also was when preparing for this live, I was reading some articles, and I came across the article that was talking about one condominium that became a victim of a class action that was lost by the condo association and won by the plaintiffs, and the condo association awarded $300,000 in in fines and attorney fees. So how do people fight it? So basically, if a person is buying a unit or is renting a unit, and the person clearly sees that the condo association is not right because it charges you $200 or $300 in moving fees, what steps do you need to undertake as an applicant? How can you fight for justice?
Okay, so let me take one step back, because a transfer fee, okay, that's by statute, is different from, say, a security deposit or some sort of a deposit, right? If you put a
Sure.
deposit down and it's refundable, or if you put down, if the association requires you to put down a security deposit to protect against damages to the common elements or the association property, that's different, right? So a transfer fee is one type of fee, and then you have another category, which is the security deposit. And again, even in the security deposit, it could be a security deposit for the association or the landlord, meaning the condominium owner that may rent out the unit. They also have a right to collect a security deposit against, that unit for what the individual tenant, has or establishes through that unit. Okay. So, going back to that. So this transfer fee issue, and again, there has been some media discussion, and most notably, there was a Miami Herald article about that where
Yeah.
they did some sort of a statistic or a survey, and they found that over 40% of the condominium associations here are in violation because they are collecting in excess of that $100 limitation. So while condominium association attorneys, they try to talk to their clients, the association say, hey, don't do it. But of course, there's that tendency to cover costs and so forth. So I think there are 4 different ways to really look at this. If you are being charged, let's say you are transferring a title or transfer or a sale or lease of the unit, and you're moving in or moving out, as the case may be, or a tenant is moving in, and you see that fee is not correct, or you're being excessively charged, or it's in violation of statute. So the first thing you want to do is really probably knock some sense into that association and say, hey, you're in violation of the law and you can't be doing that, and raise it up and say, this is not right, or go talk to your attorney, your association attorney, but you should not be collecting those fees are exorbitant or, again, prohibited by statute. So talk to the association, try to work out the resolution of that. So the next step is, if the association is unwilling, either they don't understand or they're adamant about it, you can file a complaint with the Florida Department of Business and Professional Regulation. So one of the unit owner disciplinary guidelines provides in the Florida Administrative Code that, again, a violation of the transfer fee provision in the statute, that is a violation of the Condominium Act. So you could file a complaint with what we call the DBPR. It has been discussed that you could even file a complaint with the Attorney General's office, although I haven't seen that particular remedy. And then the last resort, obviously, there are attorneys that handle these types of cases. There's somebody in Miami that's, well known, that does this type of work. But hopefully, if you think you're being overcharged, the starting place is just, talk to the association and put them on notice that what they're doing is just, it's in violation of the law.
And it's interesting. I also read in the article that there is a new rule to the Florida Administrative Code that allows DBPR to be more active, and condo associations that are charged with inflated fees after the date of December 5th, 2018. And if such condos are investigated by the DBPR, they can face a fine of up to $5,000. So I'm sure that there is no condo association that wants to face such fine. But I think that one of the reasons why people are fighting very little is because Florida is filled with foreigners, with immigrants, or with with people who have just received their citizenship. So they just do not dig that deep into the laws, and they pay this $200, $300, $400 fees just to get the desired unit and not to jeopardize the real estate transaction. So in my opinion, it's one of the reasons why we do not see a lot of changes in the condo association policies that decrease their moving fees to the $100 that is mandated by law.
I think that's exactly right. I mean, it's a pretty straightforward thing, right? If you filed a complaint with the DBPR, it either is or it isn't. Either you're charging 500 or you're charging $100. It's pretty obvious based on whatever statement or invoice or bill that the association provides. But again, it's twinfold. The buyer might not know what the Florida law is because the buyer or the renter is from a foreign domicile
Country.
or out of state.
Yeah.
And then the association may not know that what they're doing does not comport with the statute. So I think you have both sides that may or may not really know, what the law is. That's why it's so important. And I commend you for this type of outreach, because you have to know your rights. And that's the whole basis for all the workshops and the things that I do, because know your rights. That's really what it's about.
And I think it's important for people to, gather the like-minded people in one group, because if you file a suit as a class action, so to speak, you have way higher chances of succeeding versus being a lone wolf. And, another interesting statistics from that same Herald article is that roughly 4 in 10 condos listed for rent or sale charge transfer fees in excess of $100. So that's almost 50%, as you mentioned. I think you also said over 40%. I think that's a very significant number, and people really need to do something about it, because unit owners pay so much money already in condo association fees that I think that's an absurd for the condo associations to overcharge people in transfer fees and application fees and move-in and move-out fees. I mean, sometimes you get lost in how many fees you end up paying throughout the course of your residency in a condominium.
Right, and I will say that it does not appear to me, I'm not a litigator, but it doesn't appear to me that this is settled law or there's big case precedent at an appellate level. So it wouldn't take much for the Florida bar and the association attorneys to maybe band together and maybe try to change the law to give more concessions or allow the higher fees. But until the law is changed, this is what the law is, and the associations have to comply with that. And
yes,
go ahead.
Yes, no. I apologize. I just was agreeing to what you were saying.
Right. So the security deposits, I just want to make one other point, that unless the documents provide for it, the association really cannot collect a security deposit. While it's
the association cannot collect,
unless they can, if it's in their documents, it's in their declaration of condominium. So the transfer fee, kind of a statutory thing, but if in the event of a security deposit, it really needs to be in your declaration. So again, I stress, as I do always, read the documents, know your rights, read those. They may not be the most exciting reading in the world, and I'm one of those people who drafts them. But you got to read the documents and know what your rights are, because again, that declaration is like a contract between you and the condominium and the association.
I think one of the reasons why people sometimes are very reluctant to read such documents is because you spend so much time and energy finding the right apartment, finding the right place, that by the time you finally find it and you negotiate the price with the seller or with the landlord, you are just tired and you want to be done with it, and you just want to move in and enjoy your peace and quiet. And in my opinion, it's really one of the reasons why condo associations on many occasions do not comply with the law because they do not have necessity in doing so unless there is a very active resident who will take action and fight for justice and for what is right.
But think about that. If one person says, you know what, I was overcharged by $100 and starts knocking on doors, and think about the consequences. So that's why
Sure.
you got to know what the law is, and you got to know what's in your documents. So, and you're right. It's a very, I think the purchase of a condominium unit is a very visceral, it's a very emotional experience. You fall in love with that, and you don't sometimes think about the consequences of, hey, what kind of restrictions does this how is this association formed? What kind of restrictions are there? That could have consequences for you for a very long time.
Absolutely. And I think here in Florida, especially, it's very important to fight for what is right, because the condo association, because besides the condo association fees, you also have to pay first, last, and security. And we know that Florida is more, landlord lenient state, so to speak. It's more on the side of the landlord. So that's why tenants have to come up with 3 times the rent up front, including the security deposit, unlike, for example, in the state of Illinois, where you only have to pay first, last, and security. So that's why when you add up all of these fees plus the admin fees and the application fees, that's really a lot of money for an average middle class family. So the most important point that you brought up is that the maximum a condo association can charge you is $100. So please, everyone who is watching us right now or will be watching in the future, please remember this number, $100.
Right. On a transfer fee basis. Again, it doesn't go to security deposits that you might be required. A security deposit up to 1 month's rent, again, is dictated by your declaration. Or the security deposits, if you're a tenant, that the landlord, the condominium unit owner, who's basically the landlord, so you might have other fees as well. And there's probably a little bit of discussion. In fact, I've discussed it with a colleague about the pet registration. So
yes, that's very good.
So we always get back to the dogs. I always say in my workshops, let's talk about the dogs. What about the dogs? So
yes,
let's talk about the dogs. So if it's an emotional support animal or a service animal, again, that's not considered a pet. So it wouldn't be subject to a registration fee. So one attorney stated, we talked recently, he said, oh yeah, you can, maybe a pet registration is a little different from a transfer fee. So that's something I would check, with the specific association attorney, whether or not that's exempt from that, or whether or not that, that's considered a transfer fee. But, arguably, again, if it's a pet and a dog as opposed to a service animal, the association could require that, plus other documentation. Again, has the association adopted rules? Are there vaccination, leash, other medical, any other requirements that affect that, the ownership and management of that pet? And that's a big restriction area.
And what I would like to point out is that I do a lot of rentals, for example, and nowadays, like every second tenant has a pet, and a lot of such pets are emotional support animals. So when my clients submit their application and they point out that they have an emotional support animal, the entire moving process takes much longer because the condo association has to send the pet's paperwork to their condo attorney, and the attorney takes a very long time to review the documentation, and on many occasions my clients have no time to spare. I mean, they have a deadline, they need to move, and the attorney still has not finalized the paperwork. So what they do, they say, okay, no problem, I'm withdrawing my emotional support request, and I'm going to pay $100 for my pet just to be done with this process.
Right. And so the pet, again, is it a separate type of security deposit or a fee, whatever you call it? Because, if the pet, causes damage or, something, that they have some registration or some security deposit. But certainly, just to point out, the law recently changed about emotional support animals that might factor into the length of time it takes to review. No longer the Florida legislature basically stated that you can't certify these animals as emotional support animals just from an internet, some sort of a web-based certification. So whoever's certifying that dog, that pet is not pet, but that animal is an emotional support animal, has to have some personal knowledge about that particular, the individual and the animal. Right.
Yes, absolutely. However, the pet topic is very important. That's why I always tell my potential buyers or tenants that if you decide to move to a condo association, please be prepared to pay a couple $100 at least in moving fees in order to make the deal happen. And again, like I always have requests from my potential buyers or tenants to find them a condominium. And when they find a place that they like and they see that, oh, there is a $200 application fee and a $200 moving fee, they will not say no to this condo. Of course, they will go for it, and they will sign the lease, or they will sign the sales contract, because comparing to thousands of dollars or hundreds of thousands of dollars they are paying for the purchase of the unit, this couple $100 is really nothing. But I think it's important that people start taking action, especially those who own units, in order to in order to fight for what is right and make their condominium more desirable for the potential buyers and for the potential tenants.
Absolutely. Absolutely. Again, pet restrictions are amongst the most important and sometimes vexing, but they are super significant because arguably the renters have less choices, right? Because not all buildings will allow pets. So again,
yes,
they can't refuse an emotional support animal because those animals, have legal protections. But certainly the buildings themselves, might have pet restrictions.
Yes, and I always advise against renting a unit in a condominium that does not allow pets. And again, if you have an emotional support animal and you have legal proof of such animal, of course, technically speaking, you cannot be denied. However, I think you take a lot of chances by renting a unit in a condominium that does not allow pets with an emotional support pet, just because you might end up wasting a lot of time and receiving a rejection based on something else, not based on the animal. But again, I don't know, you as an attorney, did you have any experience in protecting those people who were, for example, trying to buy a condo that does not allow pets, and your buyers, your clients, had an emotional support pet and they got rejected or denied by the condo association?
I don't believe that the association can they're not pets. So if it's an emotional support animal and is properly certified, and there really is a demonstrated need or basis for having this emotional support animal, there's nothing that the association attorney, there's nothing that the condominium association can do.
Absolutely. I just think that on many occasions, buyers or tenants need to be more braver, and need more courage in order to stand up for themselves. Because as a real estate professional, I've been dealing with a lot of situations and a lot of condominiums, and unfortunately, sometimes pushing a deal that involves an emotional support animal can be very complicated. So hopefully in the future, there will be some laws and orders that will mitigate the approval process involving an emotional support animal.
Right, and it's complex. I've done workshops in this area, and you have pet lovers and others that have just it's we have some buildings where it's very it's a very hot topic, and something that's fraught with.
We lost Dana. Hi, Dana. Can you hear us?
I'm sorry. It's
No,
yes,
that's fine. That's fine. We can hear you, but we cannot see you.
I'm not sure what happened to the camera.
Well, we actually, yes, I think you are almost there.
I can't, okay. So I think I faded out of the picture, but you can hear me, correct?
I can hear you, Dana. And actually, we've been talking about our current topics for almost 30 minutes, and we were leaning towards the end of our conversation. So I think it's about time for us to wrap up. I highly appreciate your appearance today once again on my educational series. Thank you so much for the information you provided about condo fees and about pet fees. It is very valuable. And we will see you hopefully next week, and we will talk about other important condo associated topics.
Wonderful. Sorry that the screenshot didn't hold up, but I always say it always comes down to the dogs.
Yes, it's true. And today we proved it.
Thank you so much, Anna. It's always a pleasure to see you.
Thank you, Dana. Have a good night, and thank you for your contribution. Bye-bye. And bye, everyone. Bye, dear Facebook friends and followers.